My name is Stephen Frost. I'm chair of the British Chamber's Legal and Tax Group, and I'm very pleased to welcome you all to this afternoon's event. The event is called Debt Restructuring Through the Court, the Basics, and it's the second of 3 linked events that British Chamber is putting on in relation to debt restructuring, which is something of a flavour of the month issue. We are very pleased to welcome as our guest speaker this afternoon, Kunwaran Wanitprapa, who is co-country managing partner of DLA Piper in Thailand. Kunwaran is recognised as a well-skilled banking lawyer with experience in bank lending transactions, cross-border deals, acquisition finance, structured finance, interbank lending, export credit financing, projects, and also debt restructuring. His professional background includes years of previous experience in London, Hong Kong, Singapore, and Bangkok, and he has been appointed to advise foreign clients on inbound investment as well as domestic clients on their outbound investment projects. Warren has been recognized by various legal directories and publications such as Chambers Asia Pacific, the Legal 500 Asia Pacific, and IFLR 1000 over the past 10 years. His most recent deals have won prestigious awards, including Best Deal of the Year, Best Cross-Border Financing, and Best Cross-Border Financing, where he acted and advised leading banks in Thailand. Warren holds the role of co-country managing partner for DL Piper's office in Thailand. So I'll hand over to Kunwaran in a moment. He will give his presentation, and that will be followed by a Q&A session. Thank you very much, and welcome to Kunwaran.
Hi, Stephen. Thank you so much. And good afternoon, ladies and gentlemen, and thank you so much for your interest in joining this webinar. I'm delighted to be one of the speakers on this event and with the British Chamber of Commerce Thailand. Thank you so much for giving me this platform to talk about, well, the last 12 months has been probably the most talked about topics of from a legal perspective in Thailand, i.e. debt restructuring, in particularly through the court. If I may start, I guess the purpose of this talk, because it's the basics, so I'm just not going to go into too much details, but I would very much like people to ask me questions at the end of my slides. I don't have many of them because I personally do not believe in giving people too many pages of slides. And at the end of the day, anyone can Google and come up with all the slides and all the timeline about the Thailand debt restructuring through the court. And there's so many materials online, but it's about understanding the key principles of what this is. If I may start. So that's a bit about me. Thank you again, Stephen, for giving a bit of introduction about me. I started my career actually as a restructuring lawyer during the Asian financial crisis. I was a junior lawyer at the time at another international firm in Bangkok, and we, together with my boss at the time, were representing Creditors Committee of the first debt restructuring through court in Thailand called Alphatech, and then we led on and represented various companies and creditor committees on most famous and the largest debt restructuring deals in Thailand at the time, like TPI, Pauline, and UCOM, and so on. So debt restructuring with or without court. I think here the topic is about doing it by court. But then coming back again, this is one of the most significant questions that people would ask. If you are an advisor, or if you are a company, or if you're with a bank, are you asking when something goes wrong, whether how wrong could this go? do I actually need to push this debt restructuring under Thai rehabilitation? And there are obviously pro and con. Cases without courts, obviously, there are, let me take it back. If you are in control of the whole picture, in the sense that you, the company, and a key creditor, or the most significant lenders, if you have more than one lender, you on good term, you sort of trust each other, and you can well, I wouldn't necessarily say manipulate, but manage other creditors to come to the table to discuss and talk about what are we going to do. Like, we're going to give the company a few months not paying interest. We're not going to take any action against the company. Why the company has to improve its performance, why the company have to either sell the asset or generate more cash to be able to service debt again. At the very beginning, when people sit down, when I say people, I mean obviously the company and key creditors, if they manage to sit down and have some sort of trust and arrangement with each other, that until we really find out what are we going to do to fix this problem forever, we will all be sitting here. No one will take any stupid action. You won't start taking the company to court, and the company will not start, say, borrowing more money, spending more money in a way that's not approved by key creditors. That's the very beginning. If you have that trust, you can sort of sit down and think carefully, well, am I, or are we in control of the situation? Apart from us, people in the meeting room, on the table, is there any other creditor out there, small creditors or larger creditors, who may not necessarily want to take a part in this, and then want to start taking actions against company? Or even with all the creditors are sort of on the same terms to sort of stop taking actions against the company in wait and see first. But do you trust the company not to ruin the financial performance or the ability to repay the debts even further? If largely speaking, you say, well, you can, for the time being, trust the company. Maybe it's, and you can control the process in the sense that no one would be able to bring the company down, either taking action in court against the company or start enforcing security and so on. You may not need to start the court process yet. The reason why people need to think about this quite carefully, because once you start the, if you realize that you actually not in control of the situation, there are too many creditors, and there's very little trust between all parties amongst the creditors, and between the creditors and the company. That is when you need to start thinking about putting your debt restructuring through court, so-called rehabilitation process, or Thailand Chapter 11, because once you started, it's not easy for you to come back. It's not something that you can start the process, and then when you don't like it, you realize that, okay, I have initiated the process, rehabilitation process, and now I begin to trust people on the other side, or my fellow creditors more. I want to stop this process. It doesn't work that way. So you have to think quite carefully before you start this process. Right, the court process, it was actually launched in response to Asian financial crisis back in 1998. I just finished my law degree back then. And it has always been known as Thailand Chapter 11. I think it is less known now. Now people refer to it as Thailand Chapter 11 less than in the past, but the whole idea and the whole legal procedures behind were largely following US Chapter 11 in response of the Asian financial crisis at the time. Before this rehabilitation proceedings in Thailand, we only have bankruptcy proceeding. Ideally, it's just to save the company from going bankrupt, and to find a way that the companies with massive financial difficulties and lots of creditors could come to some form of arrangement which would allow the company to come back uh, and be in a healthy financial position again, and do a deal with creditors in a way that overall, yes, creditors will not necessarily get everything back as they thought they would at the very beginning of the process when they start doing the business with the company. But the bottom line is it would give them more than putting the company into liquidation. So the anatomy of the whole entire process of Thailand debt restructuring through court or rehabilitation, we have a few steps here. Petition file, that's relatively easy. You file petition with the bankruptcy court. There's a few key items that you need to satisfy, like the amount of debt and the ability to restructure the company. And if once you restructure the company through court, it's better than putting the company through liquidation. And one of the key factors is that the company is insolvent. The key take out of this, which did not happen in relation to Thai Airways, is that typically for a very successful debt restructuring through court, before a petition is filed, this is a petition to seek the court order to put the company into rehabilitation. Before a petition is filed, a successful rehabilitation would be able to submit the petition with supports, i.e. signatures of enough number of creditors, and a key terms like a term sheet attached to the petition. In other words, you go to the court and say, look, the court, we'd like to be starting the rehabilitation process, and here are our supports. We have the signatures of the following creditors. In total, they represent enough debts which would push us through, or which would be able to approve the plan, and the terms of the plan would largely look like this, and here's the attached term sheet. And this process is actually very important because you don't necessarily want to go into the court unless you know that it would be a successful rehabilitation. Going to the court is a lengthy, expensive process. It has a lot of protection and has a lot of benefit, but to be successful, you need to sit down with enough number of creditors if possible, or at the very least, the largest financial lenders who would be supporting the entire process. And then the next step, that's self-explanatory. So the court would look at your petition and and have the sort of initial order accepting the petition. Once the court accepting the petition, this is separate to the fourth bullet point, the court making a business reorganization order. This is the court just look at the petition. You have a strong ground, you have a good ground that the company should go into rehabilitation. Therefore, the process kicks in that the court accepts the petition, and immediately automatic stay or standstill is triggered. And this is probably one of the most important elements as to why we put a company under rehabilitation, because automatic stay, or so-called standstill, basically would stop the creditors from taking legal actions against the company. Creditors cannot receive any repayment. Creditors cannot enforce security. Creditors cannot take possession back or whatever the creditors lease to the company. And separately, also under automatic stay, because obviously the company is in financial difficulty, it has not been operating successfully from financial perspective. Automatic stay also stops the company from disposal of any additional assets, from making any repayment, from basically doing anything at all which would prejudice or which would weaken the company financial position even further, except for actions which are necessary in ordinary course of business of the company. So the key take from this is that it's not just anything which is in ordinary course of business of the company is allowed. It has to be actions which are necessary for the company to run its normal course of business. And breach, if you want to be in breach of this automatic stay provision, there's a criminal liability, fine, and prison sentences around it. So that is a key protection to stop further bleeding, if you see what I mean. And also, one thing that would make a debt restructuring successful is trust amongst the creditors. A creditor is willing to give in his or her rights as long as other creditors are willing to do the same. And if you have a few creditors and you can sit them all down at the table and say, look, I won't take any action against the company as long as you won't take those actions either. That's a good starting point. But in a debt restructuring through the court, most of the time you find some creditors who are not willing to do so, or would be willing to do so with certain conditions. Automatic stay would help you, would allow the company to breathe, to survive without a creditor trying to come and take any action against the company, knowingly that not only me, who are prohibited from taking a legal action against the company, but all other creditors are also prohibited from doing the same thing. At the same time, the company has to be very careful in terms of what they are doing in spending, making repayment, which is all stop, and can't start, basically can't start taking actions which would prejudice or which would worsen financial position of the company even further. Then this automatic stay runs from the day that the court accepts the petition, which would normally take less than a week after the petition is filed, until the very end of the entire process. So automatic stay is always allowed. Another key thing is that if there's an action, because the company in this position sometimes need extra cash to allow it to have some liquidity to run the operation, and needs to enter into a facility agreement, or even need to engage a lawyer or financial advisor, which it would otherwise be able to in a normal situation. The practice has always been that the company would seek a court order allowing it to do so, from engaging a lawyer, financial advisor, or entering into a facility agreement to obtain additional cash to assist its lack of liquidity. And these are very important that the practice for the past 20 years, all the lawyers who work in these fields would tell the company that, like, you can't do this and that, because the practice is always like you need the court order allowing you to enter into those transactions or make payments for your servicer contractor to continue to do the work. And then the next step, you have the court would make a business reorganization order that probably would take a few months after the petition is filed. And then once the court make that business reorganization order, two things starts at the same time. First, all creditors are required to submit a claim at the official receiver. The official receiver is, unlike many other countries where you have a liquidator, which could be a company like PwC, Ernst & Young's, basically like a private company running the process. In Thailand, we don't have that. Official receiver is basically a civil servant in charge or appointed to be in charge of a company that is subject to a business reorganization order. One of the key functions of the official receiver is to review all these claims submitted by creditors. Like, for example, in Thai Airways business reorganization proceeding, all creditors of Thai Airways, including those who bought tickets and tickets got cancelled, small bond holders that bought bonds, like family bond holders that not institutional investor, basically anyone who's a creditor who would like to be repaid by a company under rehabilitation proceeding is required to submit this claim. And the claim has to basically refer to the debt that the company is owed to you, and to confirm your identity, you're a person, you're a company, you're a trust, and you're a foreign company, you're a local company, and so on. And this process is actually could be quite costly and time consuming if you think about like 10,000 creditors having to submit their claims, and then the official receiver have to review those claims. The claims will also be reviewed by other creditors and also reviewed by the company. The idea of all creditors filing all the claims is that not only that automatic stay would stop the company from going further in the sense of like being poorer. So automatic stay stop the company from losing further assets by stopping the company from making any payments or selling any assets, and stop the creditor of the company from taking any actions against the company. In the meantime, creditors who claim that this company owe me X and Y would all have to confirm. This is an official confirmation process that everyone would have to identify that I am company X, I am Mrs. A, this company owe me this amount, here are all the evidence and support. And the evidence and documents supporting the claim would have to be reviewed by everyone in the process. Not only that your claim is reviewed by the official receiver, it's also reviewed by other creditors and also reviewed by the companies. If you see, this is how the basis of debt rehabilitation is where it stands still, and at the same time, everyone who claims that the company or he or her something would have to be tested whether that claim is real. The purpose of that, once you know that the entire debt amount of the company that has been reviewed and investigated by the all parties concerned, you can then start putting all those claims and put them in various categories when you prepare the plan, so as to ensure that the plan is achievable. And only when you know the identity of all the creditors and the amount of debt owed to those creditors, you can start working out the plan. The plan, immediately after the court making the business reorganization order in my bullet 5, the creditors start filing the claims, that each creditor doing his and her own things. Then the planner will also be appointed for the purpose of preparing the plan, and you have 5 months that could be extended to 7 months. The plan basically is the business plan of the company, in that once the plan is approved, how are you going to repay all these creditors who have submitted the claims? What are your business plans? How are you going to divide all these creditors into various groups, and how are you going to treat them? There's the plan has certain items that need to be addressed as required by law. But if you the idea of the plan is that at the end of the day, the plan would give the creditors more repayment than the amount that the creditors would have received had the company been put into liquidation. That's one fundamental important thing. And the plan would also say things which very importantly is to divide creditors into various groups. Typically, you see secure creditors, unsecured creditors, trade creditors could also be divided into various groups, those that are necessary for the business of the company, and those that may are less likely to receive the full repayment or the high percentage of repayment of the debts because of the business necessity has changed, and the company might have enjoyed the services or goods from whatever creditors already, but may not necessarily need to continue to do business with that company. So that group of creditors may be classified into another group. The idea of the plan is that you need to think of the plan like a very big, complicated syndicated loan. On top of the fact that the plan would list out how are you going to run the business, who's going to run the business. The plan is basically setting out the terms of repayments owed to each group of creditors. So the closest legal documentation to the plan, in addition to all the basic requirements that the law sets out that you need to address in the plan, are things that would be very similar to a syndicated loan agreement: repayment terms, interest, representations, warranties, even of defaults of the company. And once there's a trigger event of default, the plan, there might be a change to the plan, there might be a change to the plan administrator who is in charge of implementing the plan. And there's also a role of creditors committee representing the interests of all creditors to ensure that the plan administrator in charge of implementing the plan is doing his or her job. The plan, the key issue that the plan get challenged the most is how you treat a different group of creditors, because again, the whole point of putting the company into rehabilitation, because the company can't repay everybody. So that comes to when you can't repay everybody and you put people in various groups, you might write off this debt of this group 10% and another group 25%. That's okay. Fundamental point is that you have to treat creditors in the same group exactly the same way. And that's where the difficulty begins, because when you classify creditor A in the first group that is subject to 10% haircut, as opposed to putting him in another group, in group 2 with a small amount of haircut, you need to be able to justify that, because that's the most important or most frequently topic or issue which a creditor would challenge the plan. The plan needs to be voted on by creditors in order for it to be binding against all the creditors. The law has changed recently that now you no longer need 2/3 of creditors supporting it. You only need 2/3 of creditors in one group to support the plan. And as long as the number of creditors approving the plan in total represents just half of 50% of all the debts of all the creditors submitting the filing to the official receiver, the plan can go ahead and get a green light. And then the plan will get another court approval, i.e. rubber stamp. I hate this word when people say rubber stamp, because during that time, when after the plan has been approved by the creditors, there's also some creditors who can challenge the validity of the plan with the court on the ground that the plan does not treat him or her fairly. And again, one of the key or most commonly challenged issue is that a creditor feels like he or she should belong to another group that treats him or her better. So once the court approved the plan, assuming that all those challenges are rejected by the court, and the court approved the plan is binding and enforceable upon all the creditors. And this is very important in the sense that to have a successful debt restructuring, you want a plan that it doesn't matter whether you like the plan or not, but if the plan is approved by the creditors and by the court, you are bound by the terms of the plan. For example, on Thai Airways, there's a large number of creditors who would not necessarily be happy with the plan that would delay the repayment, that would reduce the interest. But it doesn't matter. If the plan is supported by enough number of creditors as required by law, and then ratified by the court, the plan is binding, and the terms and conditions that you have with the company under your original agreement, it's gone. Either the plan is considered a novation of your existing term, or in some school of thought, maybe the plan would just stop your existing contractual relationship. It comes to the point that the plan is legally binding, so you will no longer have existing terms that you could rely on to make any claim against the company. So that would be the overall pictures or anatomy, if I may say that, of the debt restructuring through court. And then, yes, there are some challenges. Again, unless we have to, and if you could sit down with key creditors and you have enough support, sometimes companies and important or significant creditors of the company going through financial difficulty would say it's just too expensive and too many parties involved, and because there's certain things that you can't control. Another trick before I go to the details of like why they are expensive and timely. If you have certain control of debts or of creditors holding enough debts to push the plan through debt rehab, through the rehabilitation proceeding, sometimes when you negotiate with a creditor who may not necessarily like to be part of that negotiation, to stop taking actions against the company, and a creditor may say like, look, no matter what you key creditors are negotiating with the company, we don't care. We are going to enforce our rights against the company. Sometimes as a lawyer myself, sometimes we just have to talk to those creditors very politely and say, look, if you are going to take those actions, we are going to push the company to rehab. And then we're going to write off everything that the company owed to you. And that happens. So you can use that, if you have enough support, you can use that argument to bring people to start acting a bit more reasonably before you decide to take the company into a rehabilitation. You tell them, we now have enough support to push the company through a rehabilitation and to approve the plan. And in this plan, we might say that we would not be paying you anything. Your total debt will be written off. And that happens, and that would allow the company, not the company, allow the enough number of creditors which would be able to push the company through the plan to have more bargaining power and stop the company from having to go through this rehabilitation proceeding. It's expensive because we're talking about a process which would involve so many people. If you push the company through the plan, all creditors would have to submit the claim with all this documentation to the official receiver. You always need to seek a court approval if you want to enter into, even to appoint a lawyer or financial advisor, you need a court order, or at least people would tell you that you need a court approval. And then it's timely. You're looking roughly at least 1 year to have your business plan started by filing the claim, filing the petition, waiting for the plan to be drafted, to be challenged, to be reviewed, and to be approved by the creditors and by the court. And too many parties involved. I mean, if you don't need to, why would you? Because you're talking about official receiver and the court, the planner, plan administrator, creditors committee, and in fact, you still have financial advisor, accountant, you have legal counsel on various sides all the time, because the process get very there's a lot of procedures to be complied with. Therefore, people are, as opposed to talking in a meeting room of like how to achieve your commercial terms, which would be binding from a contractual perspective, to help the company forward together. When you push the company into a rehabilitation, there's so many steps required under the law, and so many parties involved. You don't know whether the official receiver would agree with your claim. You don't know whether the planner or plan administrator will actually submit the kind of plan that you expect to see. And that's it's very expensive when there are too many parties involved and concerned, because you need to start appointing advisor, not just financial advisor, but also accountant and legal counsel at every step. I think we sort of cover why doing it. Protection, I talked about it. the power, claim filing, investigation. I think that's it. Stephen, if I may give the stage back to you.
Okay, thank you very much, Warren.
You're welcome.
I can't see any questions that have come up so far. So perhaps can I try and start the ball rolling a little bit? I have two questions. The first is general and the second is more specific. My first question is, regarding your current experience, the current atmosphere here in 2021, do you think distressed companies, they're more resorting to voluntary agreements with their creditors, or is it the case that the debtor or the creditors are putting the case into court proceedings? So that's a general question. The second question is, I understand that for the plan to be approved by the court, the debtor has to be proved to be insolvent. And insolvency is defined not just in the law, but also in precedents over the past 20 years. So if it cannot be proved that the company is insolvent, it's only distressed, then I guess there is only one option, that is to rely on voluntary agreements with the creditors. So those are my two questions.
Thank you, Stephen. The first question, I think we definitely see more, of court rehabilitation or debt restructuring via court in presumably in the next years. I think obviously the companies in the given COVID situation, companies have talking or seeking approval from their lenders and creditors to extend their repayment terms and to relax various covenants in their agreements over the past like 12 to 18 months. And for those that you wouldn't see debt rehabilitation through court straight away, but we have seen a lot of negotiation, a lot of relaxation of terms under financial agreements, loan agreements, and various contracts over the past 12 to 18 months as a result of COVID-19. And those that do not manage to get out of the problems will be pushed through the court rehabilitation proceeding more. So I believe in the next 6 to 12 months, you see smaller sort of, I do not expect to see another Thai Airways soon, as in like the size of the company and thousands and thousands of creditors, but I expect to see more companies of sort of large scale, not massive, maybe medium to large scale, to go into court rehabilitation a bit more, because they have utilized whatever extensions or relaxation provided by the financial lenders and by creditors already in the past 6 to 12 months. So that's the first question answer. And then the second one, correct. If you can't prove that the company is insolvent, there's no way that the court is not allowed to push the company into rehabilitation unless the company is insolvent. And to be insolvent, I mean, the easiest thing is to prove that like the assets are less than liabilities. But there are a lot of assumptions under the law where, okay, if you stop making repayments for a period of time, if you start moratorium or letting your creditors know that you can't repay them in general, there are various assumptions under the law which would allow companies to go into rehab. But strictly speaking, if you go into rehab these days, a successful rehab would also be a rehabilitation that both company and enough support creditors together file a petition, as opposed to creditors forcing the company to go into rehab, or company wanting to go into rehab without support of creditors. So if you are in a situation where both parties, when I say both parties, I'm not talking about every single creditors, but enough of them, and in particular, large lenders or key creditors or key financial creditors, if they support the rehabilitation, they would co-sign the petition to the court, and the issues around whether the company is insolvent or not is less challenged or less questioned by the court when the creditors and also the company believe that here the company is insolvent. We need to fix this company.
Okay, good, thank you. We have one question come up from Lawrence Knowles, and he's asking about the percentage of creditors who have to agree for the court to accept the initial petition. It seems to me there's two issues here. The first issue is, what does the debtor have to, or indeed the creditor, have to prove for the court to accept the petition? The second issue is the percentage of creditors that need to vote to approve the plan.
I think the second issue is to approve the plan. Now it's actually relatively easy. You only need majority of the creditors, as long as in one group you have 2/3 of creditors in that group supporting the plan. But overall, as long as you have the support of majority of the creditors, 50% plus 1. So, and in terms of the this is a question from Lawrence. Thank you, Lawrence, for the question. Typical percentage of creditors in agreement for court to accept initial petition. Actually, there's no requirement. Like, for example, for Thai Airways, my understanding is that there was no creditors officially supporting the petition at all. But the more, the better. And if you have support of, say, creditors representing enough percentage to approve the plan, that would be terrific. Say if you have more than half of credit, the number of creditors, it doesn't matter. As long as that creditors representing more than half of the debts, supporting the idea of the company going into rehabilitation and co-sign the petition, that would be really good, but there's no strict legal requirement on that. It's just the more the better.
Okay, thank you. Second question has come up from Kun Nikom. Warren, it's a bit difficult to summarize because he asked several questions. Can you open the second question from Kun Nikom?
Yeah, okay. What's your opinion on the travel and tourism company as well as hotels, several moratoriums and also initiatives from the BOT? Will that help, or would you expect more rehab going forward? Also, how will the rehab go as the future remain uncertain while the border is being shut? I love all this question. I'm not sure necessarily whether they're legal, but I guess several moratoriums, obviously, it's arrangement between financial lenders, banks with hotels and companies in hospitality business. And yes, banks are being strongly suggested by the Bank of Thailand to allow this moratorium. But at the end of the day, we have to come out of this. And I personally think that I don't know whether I'm addressing the question correctly, but to avoid the company from going to rehabs, companies need to speak, need to gain the trust of your key financial creditors and work on the restructuring together. When I say work on the restructuring together, financial lenders are very experienced when it comes to debt restructuring, and they're definitely going to be more experienced than you, the company, whether or not you need to go into rehab. So for companies in travel and tourism, basically just talk to them and say, look, we can't pay this, and we have these creditors who are going to take actions against us. What are your advice? And your key financial lender who would take you as client would say, well, based on our experience, if they start or if they are making any threat to take legal actions against the company, we would support you, or we would tell them, look, let's sit down and don't do this, don't take this action. Now we're helping the company together to stop the company from going too deep in to the problem. Your financial lenders, as long as you gain the trust that you're playing the right game with them, could also become your advisor in talking to other creditors who would want to take legal actions against you, either to bring you to court or to enforce security or to stop trading with you and so on. I think that definitely be more rehabs going forward, but I hope if Thai banks are very experienced with rehab and they know exactly if they really need to push the company into rehab, as long as you keep the relationship close with the bank that has the largest portion of the debt. Say if you borrow from 5 banks, the one that you borrow the most should be the one that you seek advice from, to talk to other banks and other creditors and to give you advice in terms of how to talk to other creditors, because they would provide a strategy. They would also give you experience that like by putting the company into this rehab, it doesn't work this way, or we need X and Y and Z before. We need to come to some form of agreement with all the key creditors before we put the company into rehab. I think, I hope I answered that. Yeah, thank you.
Okay. Second question from Lawrence Knowles. If there's a group of companies with the same creditors, but the debts are spread across the different companies, does each company need to file an individual petition to the court, or can it be filed under one petition?
No, you have to file them separately because the identity of the creditor is very important. So you can't file a petition together. I mean, I guess from the commercial perspective, as long as your claim tells enough that like you are filing the petition together, it doesn't really matter. But from a legal perspective, it's been the practice, because again, we're dealing with the official receiver, the civil servants here. They have a particular form that you have to download it from. It's an official form with a giant Garuda at the top, and the identity of creditor will be once you file a claim, you are given a number as creditor number 1, 2, 3, 4, 5, and the form itself does not allow you together more than one creditor to file one claim on the basis that you are related creditors.
Okay. Yeah, there's a number of questions coming in now. Okay, there's a thank yous. Warren, I don't practice very much in this area, quite frankly, but I still think it's the case that Thailand Chapter 11 only applies to corporate entities. It doesn't apply to individuals. So
no, it doesn't.
An
Correct.
individual cannot go to the court and ask for the court support and ask for all these wonderful immunities. So, for example, if you've got a company or a group of companies that's carrying around a bank debt of $50 million, and that's subject to a guarantee from a key person, either a shareholder, a director, or an outsider, the bank decides, well, we can't get our money out of the company. Let's sue the guarantor because he's got no right to go to the court and ask for restructuring of his debts.
In that case, unfortunately, this rehabilitation proceeding do not apply to individual yet, but I guess from legal perspective, an individual can be given this protection while a bankruptcy proceeding, but obviously no one wants to be declared a bankrupt person. But if you are, these sort of stays or protection around you as an individual would also be given to you, but that would come with various limitations that you're no longer allowed to do any transactions, to open bank account, and to serve and to be a director of companies and things. But it is a way for individuals with debts that they could never repay to restart again, if I may say, because once you declare bankrupt, you have for a period of a few years, I think it's you can come out of bankruptcy and start clean again after 3 years, which means like all of that debts are forgiven. But then again, your reputation is very hard to come back from reputation perspective.
Yes. So an individual can go bankrupt, and the issue is resolved in that way. But as you say, that might damage his commercial reputation in the future, and his ability to get a bank to accept him as a guarantor.
Indeed.
Yeah. Okay. Yes, so Warren, here we are in September 2021. You said in answer to Kudnikom that you do see more rehabilitation applications being filed in court. So, you know, looking into your crystal ball as best you can, how do you see things working out over the next 12 months or so? Are we going to see a repetition of, you know, some of these very nasty and bitter disputes that occurred 20 years ago?
No, yeah, I'm pretty certain that we won't. I mean, I guess it's very different scenarios here. 20 years ago, all the largest companies in Thailand were struggling, but this time around, SME suffered the most. And Stephen, like last year, listed companies in Thailand made more profit than ever, and Thai companies raised funds in the stock exchange, #1 in Asia after China. We managed to raise to have the largest IPOs, three rounds within 12 months despite COVID. So this is a completely different situation here, and banks are still making money. Big companies are still making money. I guess I'm not saying it's the right thing, but Thailand is like many places in the world, and in many ways probably worse than many places in the world, where the rich are getting richer from the pandemic, and biggest companies in Thailand, which are owned or controlled by the richest families, are doing really well. The struggles you see the most with smaller or medium-sized companies. And yes, of course, like Thai Airways is an exception, because the problems were all there, and it is directly affected by the no travel situation. But in terms of like the super big sizes companies like 20 years ago, when basically every single largest Thai companies were struggling 20 years ago, I don't think you see it this time around. You look at their profitability, you look at how successful they were, and you look at the you look at the stock market managing to raise 3 largest IPOs since the establishment of Thai Stock Exchange last year. So we're dealing with a very different scenario here.
Yes, I agree with you with respect. I mean, 20 years ago, there was absolute chaos in the financial sector. What was it? 56 finance companies were shut down.
Correct.
And 7 bank chains were shut down. Now, I think today, 20 years later, I think that the banks, having gone through the 1997 crisis, have far
Yes.
more experience and expertise, and perhaps they're more willing to step in at an early stage if they see that one of their customers
Absolutely,
has
Stephen.
problems servicing the bank debt. You're going to get, the MD is going to get a phone call from the bank and saying, could we possibly have a meeting to discuss your current situation? The bank is concerned to try and help you as best they can.
I completely agree, Stephen. And if you take back to global financial crisis in 2008, Thailand did not really suffer from that at all. Like, it was a big global financial crisis, but Thailand had the really expensive experience from the Tom Yam Goong crisis back in 1998 to 2001. Therefore, when the world changed to global financial crisis in 2008, the banks, in particular local banks, were all very, very strong. There were very few Thai companies with any kind of problems, and there were no Thai banks at all in any kind of crisis during that time, when basically the rest of the world is global financial crisis. And this time around is the I mean, it's a different situation here, but I still see that, like, sadly, most people who suffer are smaller companies, whereas and that allow larger companies to even be stronger, to even be richer. I guess we're not talking about whether it's the right or wrong, but what it is. And what it is that Thai largest and most sophisticated companies, including banks, are actually making more monies in the crisis. And that's not just Thailand alone, it's the same in the US and the same in many other places.
Okay, Kun Lawrence has come back with another point about this inability for individuals to take advantage of the Bankruptcy Act clauses.
Yeah, Lawrence, the individual can be a creditor. We were just talking about individual being a debtor subject to the debt rehabilitation or court rehabilitation process. It's not available for individual as a debtor, but as a creditor, you could be an entity, you could be an individual to initiate the process, or could have your rights fully protected as a creditor. You could file a claim, you could vote in the creditors meeting. Your entitlement and your rights as a creditor, either individual or a company, are exactly the same.
Okay, well, we've come to the end of our allotted time. Hold on, there's just one more question come up. So thank you. Can I say to Kun Warren, thank you very much indeed on behalf of the British Chamber for your presentation this afternoon and for the benefits of your insights, both in relation to the current crisis and indeed your perceptive comments contrasting it with Thailand's experience with the Tom Yam Goong crisis 20 years ago. So Warren, thank you very much for your comments and for your thoughts and your presentation this afternoon. It's very appreciated, and thank you very much on behalf of the British Chamber of Commerce.
Thank you so much, Stephen, and thank you so much, the British Chamber of Commerce, to allow us and DOA Piper to present this from a very insightful. It's a short presentation, but I hope that the audience find it useful. And if any questions, I'm here. We have a full team, full service here, 40 lawyers, and we're very experienced debt restructuring lawyers, either in court or outside the court. We have the full team to support you.
Okay, thank you very much, everyone.